Good evening, ma'am.
Good evening, good evening.
Shall we start, ma'am?
Yeah, yeah.
Good evening, everyone. Welcome you all to this last day of 3-day workshop on data security and protection law organized by Legal Vidya. I would like to invite Manvidutta ma'am to give her insightful valuable word.
So, good evening, everyone. Today is the last session of our topic data security and protection. So, herein, today, before we start, yesterday we were talking about the WhatsApp encryption, right? End to end encryption. So the WhatsApp end-to-end encryption was driven just by a desire to protect user privacy from government and third-party surveillance, leading to major legal and public debates. So there were many cases which led to such end-to-end encryption. The most latest one is WhatsApp versus NSO group. So this case, it is the case of year 2016, wherein this case involved the discovery that NSO Group, an Israeli spyware company, was using a vulnerability in WhatsApp project. That is, they were trying to infect a small number of users, that is their mobile phones, with malware infection. So the lawsuit highlighted the security risk that were associated with vulnerabilities in messaging apps and the need for strong encryption to protect against surveillance. Then there was another case in the international hemisphere, that is US versus Apple. In this case, Apple refused to create a backdoor to unlock an iPhone used by one of the San Bernardo shooters. That is, he was the sharpshooters, one of the sharpshooters, citing that it would compromise the security of all iPhones. So the FBI's request spurred a broader debate about encryption and government access to private data. Similarly, if we talk about the arrest of our app leader, our ex chief minister, who is that? Ex chief minister of Delhi.
Arvind Kejriwal.
Yes. So, can anyone highlight the arrest of Arvind Kejriwal? What happened and how it is related to IT Act? Anyone? All right, I'll tell you. What happened was that during his arrest, his phones and everything was scrutinized by the authorities, and his phone, his mobile phone was of Apple. So Apple has its strict policy that they never give any uh, decryption to any of the authorities, although it involves any terrorist, it involves the public security. Their policy is like that they will never decrypt the data that has been shared through their platform. All right, so same thing happened here. Then in 2013, there was Edward Snowden's revelations, that is the NSA whistleblowers. You understand who is a whistleblower?
जी मैम.
Who's that?
Ma'am, a whistleblower is someone who reports a crime and his identity is not disclosed.
Yes, very good. So, whistleblower leaks reveal that some companies had been compelled to build backdoors into their products to allow for government surveillance and the exposure of a backdoor in Skype, a platform that was previously used to be secure and led to a significant loss of credibility and public backlash against the company. So that was there. So current, are you aware of current legal challenges in India related to WhatsApp encryption? There are many PILs that has been filed. Have you read any case, any PIL, any such things which is related to end-to-end encryption? Nowadays, you must have seen the advertisements of WhatsApp. They show that the chats, the conversations, that whatever we do on WhatsApp is fully decoded, like fully coded. They are not able to read it. Why these all advertisements are flowed? Because there are many legal challenges in India related to these end-to-end encryption of WhatsApp. And there's another platform known as Telegram. Have you heard of it?
Yes, ma'am.
Yes, ma'am.
Okay. So have you heard that many groups on Telegram has been blocked now?
Yes, ma'am, because they were giving copyrighted material, some of them.
Yes. So because of that, so after the end-to-end encryption of WhatsApp, the end-to-end encryption led to shutdown of many such conversation platforms, such as Skype, such as Telegram, etc. Many groups of Telegram now has been removed by the authorities. So this is how end-to-end encryption of WhatsApp began. All right. Now coming on to our last lecture. Is it visible?
Yes, ma'am.
All right. So now today we have so far what we have discussed so far.
Ma'am, we discussed about the cases relating to end-to-end encryption. And
No, last 2 days.
last 2 days, we talk about the various case laws regarding data protection. We talk about the concept of data protection
Yes.
and yeah, other concepts were covered. Ma'am.
Yes, and global laws as well as Indian aspect, right? Now today we will focus upon, I'm sorry. Yeah. So today we will focus upon the fundamentals of the judicial insights, compliance, and way forward. So firstly, we will talk about balancing rights and innovation. So, this session dwells into the judicial highlights, insights, compliance strategies, and the future of IT law, that is focusing upon the critical balance between the rights, innovation, and security in data protection. Now, tell me one thing, what do you mean by judicial insight?
Ma'am, may I try?
Yeah, please.
I think judicial insight talks about how the law perceive a certain concept to be like the legal aspect or something.
Yes, basically it is the interpretation of courts, because some words are either ambiguous or there is any unconstitutionality that is being challenged, constitutionality of any provision that is being challenged before the court, and it is the judiciary that will decide that either the vagueness of that particular provision is there, or is it is it directly compliance with the constitutional provisions or not. So, or any other challenge which has been faced by the before the judiciary, it has been placed before the judiciary, and judiciary is talking about the is solving the question of law, not question of fact. You understand what is question of law and question of fact?
Question of law would be whether the said act is violating any uh, article of the Constitution or something like that, and the question of fact would be whether that person did something like did he steal someone's watch, something like that.
Yes. So question of fact basically is on the situation that has been occurred before the court. ठीक है, any situation, any dispute that has been drawn before the court, that is the question of fact. And question of law is basically when legal challenges are being placed before the court, and it is the court who will interpret that particular word or the vagueness of that provision, and so on. All right. Have you heard of doctrine of severability?
Yes.
What is that? And under which provision?
Under Article 13, I think, I'm not sure, but it relates
Article
to
14.
it,
Okay.
14, sorry.
Hmm.
Uh, it states that if there is ambiguity in some
Yes.
provision, and
Hmm.
if the some part of it can be removed to make it unambiguous, then that should be done and not render the whole provision unconstitutional.
Yes. Very good. So it is basically that if one provision is unconstitutional, that does not mean that the whole statute is unconstitutional, right? So that is the doctrine of severability. So moving on back to our session. So herein today we will focus upon misuse of data, first stage, second, how judiciary interpret it, and lastly, how the law compliance and any future suggestions or future the future insights are there for such misuse of data. All right. So as we move on, firstly, we will talk about misuse of data. So what do you mean by misuse of data? Misuse of data specifically talks about mass surveillance, that is mass surveillance by government that raises concern about the erosion of privacy. You understand the word erosion, right?
Yes.
Okay. So erosion of privacy as centralized databases and biometric data can lead to profiling and misuse of personal information. So that simply means that whenever there is a mass surveillance by government, any example of such?
During curfews,
Yes, during curfews or
national security times,
yes,
war
during
situation.
emergencies, any national interest or public security or any public interest or security reasons. For that, if there is any mass surveillance, then in that case, the privacy can be materialized in any form, right? And the personal information of the users can be misused. Now, second second situation that shall arise is corporate exploitation. So what do you mean by corporate exploitation?
Companies misusing the user's information.
Yes, they are and is there any recent case law regarding that, or any recent incident?
Ma'am, a few years ago, Google Glasses were cancelled because they raised a concern over privacy.
Yes.
Like they gave anyone, any user, any other person's address, name, their job, everything. So they were cancelled because of that backlash.
Yes, yes. So that was there. So corporate exploitation can be in any manner, and specifically, exploitation occurs in tech companies, because what they do is they collect vast, ample amount of data, leading to opaque sharing practices, which will exploit the user information without any adequate transparency or consent from the individuals involved. So that is there. Then coming on to last aspect is lack of user awareness. When users are unaware that their shared information is being used in any other platform which has not been consented by them or has been consented by them. Now tell me, how many of you have read the terms and conditions which uh, come across wherever you log into any platform or wherever you log into any app or something similar like that? How many of you read all the terms and conditions?
Never.
Never? Yes.
Okay.
So
Yes,
that
ma'am.
is yeah.
I said we cannot do that. We just click OK and then we proceed.
Yeah. So what is that? That is lack of user awareness. We are unaware of how our data is being utilized, where it will be utilized, what is the platform, why are they using, uh, at what platform they are using our or misusing our personal data. So we are not aware, because even though they gave terms and conditions, but we don't have much time to go through those terms and conditions. That is our
Ma'am,
unawareness.
doesn't it breach, ma'am, they make it too long and too complicated wording. So doesn't it breach the transparency principle?
No, it doesn't, because they provide the whole terms and conditions. If you have time, then you should go through each and every terms and conditions, because they have explanation to each and every terms and conditions. See, I have opened that terms and conditions. So if, whenever there is any complexity in that particular particular terms and conditions, then what they do is they take you to another pop-up which will explain you what is the complexity. So that is there. Now onwards, I request you to go through every terms and conditions, so that you are aware that your personal data is not being misused by that platform. All right. So moving on. Now, what will be the effects of misuse? Have you heard of chilling effect that we have discussed yesterday only in Shreya single case? What do you mean by chilling effect? Yesterday only I tell you what is a chilling effect. See, chilling effect is fear of being watched. That is self censorship. When you yourself are afraid of watching any content due to fear or any social anxiety or any reason, societal disclosure or something like that, that is chilling effect. Okay. Secondly, loss of trust, that is in digital platforms and institutions. uh, the privacy violations erode the public trust wherever you log in any digital platform or any such similar institutions, which causes the user to question their safety and reliability, as well as it will lead to decreased engagement and reliance on technology. All right. Then comes economic damage, that is, misuse of data results in significant economic damage, including fraud, identity theft, financial penalties, and there are many organizations that face such economic damage. Yesterday, we have discussed one case of financial loss by an organization. What was that case? If anyone remembers. Okay, have you heard of local cyber cafe fraud case? Local cyber fraud case, or it is commonly known as Cambridge Analytica.
No, ma'am.
Okay, what happened was in this case, this is a case of data privacy or misuse of data. So, Cambridge Analytica case, which is commonly known as local cyber law case, cyber fraud case, or it was basically a scandal case study, which had a documentary as well in the year of 2016. You can watch the documentary on WhatsApp. So now it is your homework to watch that particular documentary. It is very interesting. So please watch it, and then you guys can yourself analyze what happened in that particular case of data privacy. All right?
Ma'am,
Yes.
could you please share the case name in the chat box?
Yeah. One second. All right. This is the case law.
Thank you, ma'am.
Okay. It is of USA. All right. And there is a documentary of the same. It may be available on Pula or YouTube, I guess. It is available on YouTube. So you can watch that. Okay. So moving on. So moving on to another need for data protection, that is uh, w- that is building a framework in such digital age, that is rapid digitalization. So rapid digitalization simply means there are many initiatives that is being taken up by the government, like Aadhaar, Digital India, etc., UPI, and digital movement that was initiated by the Modi government. Okay, so this rapid digitalization should need to go through or tag along with the protectional laws, that is cyber laws, and there must be legal frameworks to protect such personal data that is being shared on digital platform rapidly. All right. Then, talking about rising cyber threats. So, with increasing incidents of data breaches, ransomware, phishing, social engineering, etc. So it is essential to mitigate such risk and also ensure the safety of individuals' personal information. Lastly, right to privacy that we have discussed in which case yesterday?
That is the Justice K.S. Puttaswamy's case, ma'am.
Yes, very good. Uh, so, recognizing the right to privacy as a constitutional right is crucial, demanding robust legal protection to uphold individual freedoms in a digital environment. Yesterday, we have talked about KS Justice KS Puttaswamy case that highlighted the fundamental right to privacy as a fundamental right. All right, which was not declared in any such previous case laws. Now, talking about the judicial pronouncements and key ruling. Yesterday, we have discussed the landmark case that is right to privacy, KS Puttaswamy. Then there are other case laws as well. That is significant ruling like PUCL, Shreya Singhal case that shaped privacy law, emphasizing the judiciary role in balancing individual rights and state interest in data security. So, Shreya Singhal case and what happened in Shreya Singhal case? Yesterday we have discussed.
The court struck down Section 66A of the IT Act of being violative of Article 19(1)(a).
And why it was struck down?
Because she made some post about something that about a politician or something that the government didn't like.
No, I am talking about why. What was the reason, reasoning or observation given by the court due to which they struck down Section 66A of IT Act? The simple reasoning was that Section 66A goes against the right to freedom of speech and expression, that is fundamental right given under Article
19.2, ma'am.
19(1)(a). 19(2) is the restriction. All right. So 19(1)(a) is the article that is right to freedom of speech and expression, and 19(2) is the reasonable restriction that is public interest. All right. So coming on to other case laws. So there are many such case laws. I will be sharing the detailed case analysis with you later on. Don't worry. So right now I'm just telling you some major case analysis, case studies under data privacy and protection. So firstly, it was Khadak Singh versus State of Uttar Pradesh. You must have heard of this case. It is a very famous case, Khadak Singh versus State of Uttar Pradesh, 1963. Okay, I tell you. What happened was the petitioner, Khadak Singh, was a suspect in certain criminal activities. So, under Uttar Pradesh police regulations, the police conducted a nighttime domiciliary visits. And it kept surveillance on his movements. So, what was his challenge? That is Khadak Singh's challenge. The constitutionality of these actions, arguing that they infringe right to privacy and personal liberty under Article 21 of the Constitution. So, whether the issue that the question that was raised before the court was that whether the police surveillance amounted to an unconstitutional invasion of privacy and personal liberty or not. So it was held that since the Indian Constitution does not explicitly guarantee a right to privacy as a fundamental right, so police surveillance could not be struck down on that particular ground. But Justice Subbarao, you must have heard of this of his name. Justice Subbarao has a dissenting judgment in this case, which recognized privacy as an integral part of personal liberty. So this was a basis of case under Puttaswamy, that is K.S. Puttaswamy. This dissenting judgment of Justice Subba Rao was a base in forming the right to privacy as a fundamental right. All right. Then coming on to this case, that is PUCL case, that is People's Union of Civil Liberties versus Union of India, 1997. In this case, PUCL filed a PIL challenging the telephonic tapping provision under Section 5, Subclause 2 of Indian Telegraph Act, which permitted interception in cases of public emergency or public safety. So in this case, the issue that was raised before the court was whether unrestricted telephone tapping violated the citizens' right to privacy under Article 21 or not. So the court held that the telephone tapping is a serious invasion of privacy, and it is only the right of government, that is only governmental authorities can ensure such fairness, um, and also should prevent abuse regarding the telephone tapping, and it should be only in the public interest or any such national security. Apart from that, it is directly invasion of your privacy, and it is against your fundamental right, that is right to privacy. All right. Then we have already discussed Shreya Singhal case and K.S. Puttaswamy case. So these are the important case laws and judicial pronouncement on data privacy and right to privacy. Now coming on to compliance mechanism and remedies. So in this case, firstly, we will talk about legal compliance. So that is there under Digital Personal Data Protection Act 2023, which talks about organizations must establish comprehensive data protection policies to ensure user privacy and compliance with legal requirements, fostering a culture of transparency and accountability. So it has other provisions which which the current act, that is IT Act, does not possess. All right. Then comes DPO, that is data protection officers. So their roles, responsibilities are bridging a gap between the technology and law. Why? Because they are also legal officers, but they are connected to the digital data protection, and also any complaints that has been filed in any cyber complaints that has been filed before the in cyber courts or cyber cells, then these officers are particularly enforced for such complaints, right? Then if we talk about data breaches, so or any mishandling information of on a digital platform, then in this case there is a perfect procedure that is being followed by these authorities, and they follow. Firstly, they will respond on the complaint that has been filed. Then the suitable notifications will be sent to both the parties, the affected parties, and then investigation will take place. And lastly, the decision will be made, the conclusion shall be made on that particular dispute. Now, there is also audits and safeguards, that is regular checks, encryption and training, clear policies shall be And also proper training shall be given to the employees regarding the technological advancement or any such new application that has been um, installed in the computer system of any organization, right? Now, how we will balance rights and innovations, that is privacy and innovations, how can we balance that? Tell me.
Ma'am, I believe that the first thing there should be awareness, which
Yes,
people must get aware with doing online transactions and making sure that their personal information and their sensitive information is being used for the right purpose. Secondly,
yes.
there must be
Mhm.
strong enforcement of legislations in India.
Yes, very good. And also globally as well, because technology is affecting each and every aspect, each and every country. So the global laws should be also balanced in a way that it should be the person is legally protected, and there are remedies which they can claim after any such crime that has been affected their due to their data breach or any such misuse of their data, right? So firstly, handling data breaches. So there are few steps that we should follow. Firstly, swift incident response, then timely notification, then forensic investigation. What do you mean by forensic investigation?
Team of experts doing an investigation, the ones that we're
Yes, a
trained
team
for.
of experts. Yes, yes. Experts in that particular field for whatever incident has been happened. Okay, then corrective actions against the against the situation, against the cause which has been occurred, and lastly, patching vulnerabilities. So, what do you mean by patching vulnerabilities?
The loopholes in the law.
Yes, loopholes in the law or in the system that is there, how to patch or how we can move legally so that uh, remedies shall be available to us, and how breaches uh, can be led to our data violation, that is any such violation in law, and how we can protect us or prevent us for further breaches, right? Lastly, the role of data protection officer that we have discussed, that there's a key responsibilities and significant data protection. That firstly, he will oversee the data protection strategy, then he will ensure legal compliance, contact the point for stakeholders, bridging technical as well as legal teams, establishing a culture of privacy, and also lastly, when he has followed all these steps, then he will also be a part of that investigation for which the dispute has been arised, and lastly it will refer it to the cyber cell, and cyber authorities will decide upon that particular incident, and there is a cyber appellate tribunal for the same. And once you are dissatisfied with the cyber appellate tribunal, then you can move on to high court, and lastly to supreme court. All right. Then, regarding the audits and preventive safeguards, that ensuring the ongoing protection and compliance, regular audits are recommended for the compliance of such organizations. Also, technical safeguards like encryption, coding, malware, and proper biometric should be there on the system so that their information is completely secured. Thirdly, organizational safeguard and policies. Their policies, their rules and regulations, their safeguard must be followed, and their policies, their rules and regulations must be um, followed in a manner that they can prevent such data misuse, and their the information or any such sensitive data is being secured. Lastly, employee training on data protection, how shall be protected, and employees, that is uh, the persons who are working in that particular organization, should be aware of such data protection and how to manage it, how to further secure your data. What are the platforms? There are some apps particularly that work in that manner. So this is completely employee awareness. Lastly, privacy policies for clear guidelines must be acknowledged by and should be clear to each and every individual who is working in that particular organization. So that is there. Now that is it for today. So now tell me, how does the presence of shadow AI can can darker our digital platform? Have you heard of AI, and what is shadow AI?
Ma'am, I don't know what is shadow AI, but AI is the abbreviation for artificial intelligence.
Yes. So you haven't heard shadow AI?
No, ma'am.
Shadow
Yes, yes, please.
Shadow AI, I heard about it from a news article that the teachers were using the AI and the lawyers were using AI to present their arguments, like unauthorized use of employees using chat GPT or something to do the work instead of applying their minds.
So you must have also, I am not saying, but the students are also using AI. Shadow AI refers to specifically the use of artificial intelligence that she has rightly quoted, that those tools which we use for um, that has been not approved, secured, or monitored by the IT Act or department or governmental bodies. And we are using such artificial intelligence for our own use. That is public AI chatbots, ठीक है, unauthorized plugins हैं, then personal accounts हैं,